Hereby, I open this academic ceremony in which Xi Lin will defend the academic thesis entitled The Copyright Protection of Fictional Characters, Mainland China compared with the United States and Germany. And I welcome everyone present here in our beautiful aula, and I also welcome everyone participating in this ceremony online. Very good to have you all. Dear candidates, may I invite you to present a summary of your study and the conclusions of your thesis.
Thank you. Highly esteemed Prorector, highly esteemed members of the Corona, dear supervisors, colleagues, friends and family online and on site, good afternoon. It is with great pleasure that I present to you my dissertation entitled The Copyright Protection of Fictional Characters, Mainland China compared with the United States and Germany. Over the next 15 minutes or so, I will cover the background, research question, methodology, key finding, and implications of my thesis. In narrative works, characters are agents performing the plot. They are fictional if their characterization is not bound by historical accounts or facts. Depending on the media of the stories, they may or may not have an image visible to viewers. Although fictional characters are presented to viewers as parts of their source work, that is the story, they can also be used beyond the context. Their image is a common subject of merchandising in character merchandisation, as seen in Mickey Mouse keychains. They are also used for their narrative functions to perform new plots in derivative creations. In mainland China, such creations are mainly plagiarized creations, competing creations, and fan creations. In plagiarized creations, fictional characters with different names or behind different appearances perform similar plots to pre-existing works. And in competing creations, characters with the same name or appearance are put to perform new plots. And in fan creations, fan creations are by content merits similar to competing creations, only that there are non-commercial uses and the contents are only available on the internet. Right holders seem to have an inclination to exclude the uses of fictional characters using copyright. For an example, they exclusively exploit character merchandising involving fictional characters' images. They also take actions against plagiarized creations and competing creations when motivated by economic and artistic interest. However, although fan creations are similar to competing creations in terms of content, they are still widely accessible. Their accessibility thus raises the question about their legality. Either they disrupt the balance of interest that copyright maintains, or they are part of that. Therefore, my research asks this question: how does the Chinese copyright law protect fictional characters according to copyright norms and right holders' deployment? The overarching question has two pillars: the law in book and the law in action. The law in book concerns two issues. For one, are characters eligible for copyright protection? And number two, if so, to what extent? The answers to these questions delineates the claims right holders have based on copyright. And In view of their actions and inactions, it is possible to configure what they deploy, how they deploy the claims to achieve the effects they intend. The effects of the examination of the law in book compared the practices in mainland China with those in the United States and Germany due to their influences through legal transplants. And the effects of the law in action is analyzed by observing the changes in utility based on exploiting the source work. Right holders' claim deployment should be evaluated for the economic and cultural effects because the Chinese copyright law requires that its application should promote both social utility and the diversity of cultural goods. Here are the findings. Regarding the law in book, the idea-expression dichotomy is at the core. It is relevant to construing the scope of fictional character, determining their eligibility for protection, and determining the scope of their protection. According to the dichotomy, copyright should only protect expressions and it should not extend to ideas as such. It suggests that expressions, the originality copyright protects, should be formulated in a concrete manner. Ideas as such are too abstract to be protectable because the same idea can be put into various expressions. Following this spirit, a character's scope ranges from being an abstract symbol to a concrete referent. As a narrative agent in the strict sense, a character's existence ranges from its name, that is, its linguistic symbol, to the reference the name stands for, that is, the personality and the relationship with other characters, both inside and beyond the context of a story. That is the narrative function. If a character also has an image, then its image can range from being a graphic symbol, that is, the visual presentation in the style of the author, all the way to the physical attributes not bound by any style. The parallelism between ontological theories and the idea-expression dichotomy raises a question about fictional characters' eligibility for protection. Whether and how the concrete formulation of fictional characters, the formulation of originality, may justify protecting a character not only as the expression of its source work, but also as a work on its own. Works are the subject matters of copyright, and expressions are the original elements within. So, intuitively, what distinguishes a work from an expression is that a work has a form of presentation, a separate form of presentation to serve as an objective boundary to identify the original elements inside. But since copyright aims to protect originality, can the concrete formulation of originality define the scope of a work with the same certainty as form? Treaties, represented by the Berne Convention, the TRIPS Agreement, and the WIPO copyright treaties, as well as the laws practiced in the US, Germany, and mainland China, generally assume that a work has a form of presentation, a separate form. However, judicial practice are free to interpret whether originality can overtake form in the admission of work. The three jurisdictions on the issue of fictional characters join in protecting fictional characters as separate works, but they differ regarding the conditions. In the US and in Germany, it is possible to protect a character if its formulation is sufficiently concrete, or, in judicial terms, highly original to the extent of being distinct or unmistakable when taken out of the context. In mainland China, however, form is essential. A character must be proven to be presented as a work with a separate form to be protected as such. However, protecting a character as a work on its own or as the expression of its source work does not change the scope of its protection. Once we have identified the work relevant or responsible for its protection, a character as a narrative agent is always protected for its narrative function or its image. The name of the character is not protectable because it's too abstract, and the narrative function refers to its personality and relationship with other characters. If the image of a character is in cartoon style, then its image covers the physical attributes. Otherwise, the image is limited to the visual representation formulated in the author's style, if not the depiction as is. Therefore, using fictional characters can infringe copyright. In determining infringement, the judges of the 3 jurisdictions essentially consider factors in 2 dimensions. For one, they need to apply the idea expression dichotomy to protect expressions and prevent copyright protection from extending to ideas. For the other, they have to consider whether 2 works are similar to an infringing degree. The 3 jurisdictions join in protecting fictional characters from unauthorized uses with the right of reproduction and the right of adaptation. An infringement in these jurisdictions is found when an appropriation involves the image of a character or its narrative function together with the plot. The 3 jurisdictions also join in dismissing infringement when the ideas underlying the 2 works are substantially or adequately dissimilar. The legal basis in the US is the transformative use. The legal basis in Germany are the parity use harmonized at the EU level, as well as the national free use. In mainland China, the bases are judge-made non-infringement rules, which dismiss infringement when a character's image is used as the symbol, or when its narrative function is used in a context irrelevant to the source work. These rules prevent copyright from extending to ideas by denying that a right is infringed. Therefore, by nature, there are non-infringement rules altogether, rather than the exceptions and limitations subject to the review of the 3-step test in the international copyright framework. Because such limitations and exceptions dismiss infringement, notwithstanding the finding of infringement. So based on the scope of protection, it can be concluded that right holders, in fact, have claims over all these uses listed here. And they deploy claims by reserving the claim on merchandising a character's image for their own exploitation. They also deploy the claims on plagiarized and competing creations by acting to enjoin those content. They conditionally tolerate fan creation, despite that they are also infringing. The way they deploy copyright claims should fulfill the legal, economic, and cultural objectives of the Chinese copyright law. Since the assignment of claim is, by definition, consistent with the legal objective, right holders' claim deployment should be analyzed for its consistency with the legal and cultural objectives. That is, promoting social utility and the diversity of cultural goods. The economic and cultural effects are reflected in the utility of dissemination. Copyright confers right holders a monopoly to exploit a work, which is characterized by profit and deadweight laws when compared with perfect competition. These elements suit the incentive access paradigm underlying the copyright law. According to the paradigm, copyright should provide, the profit incentivizes right holders to create and disseminate work. Their exploitation thus promotes social utility. The deadweight laws represents unsatisfied demands driven to consume imperfect substitutes. Therefore, Maintaining a deadweight loss breeds demands for differentiated cultural goods. Accordingly, based on the monopoly of a work, deploying the claims on fictional character produces the following impact. We can see that the deployment of the claims on character merchandising, competing creation, and plagiarized creation at least fulfills one objective without prejudice to the other. However, in the case of fan creation, the promotion of social utility comes at the cost of cultural diversity, as it increases social utility but undermines the deadweight laws by overgrazing the content of the source work. The effect of tolerating fan creation demonstrates that the Chinese copyright law strikes a balance between economic and cultural interests in a dynamic state. The deployment of each claim does not necessarily fulfill both objectives, but the coordination of multiple claims serving economic and cultural interests at different rates increases the chance. A few implications can be drawn from this research. First, copyright is not aesthetically neutral, since the protection of expression depends on concrete formulation. Copyright favors protecting graphic over literary expressions and flat characters over round characters that develops as the plot unfolds. Second, discursivity matters in copyright. Works should be minimally differentiated, and to justify the appropriation of expressions, copyright requires not only the advancement of a different idea, but a dissimilar idea to the extent of being incongruent. And lastly, protecting fictional character as separate works can increase both the certainty and flexibility of copyright protection, depending on the jurisdiction's policy. The trade-off between these factors influence the deployment and coordination of claims by right holders. With that, I conclude my presentation. Thank you very much. I give the floor back to the prorector.
Thank you so much for your presentation. The opposition will be opened by Professor van Engelen. Professor van Engelen is Professor of Intellectual Property, Law, Litigation and Transaction Practice at our university, and he's also the chair of the Assessment Committee.
Thank you. Dear candidate, congratulations on the research you've done, and which has resulted in an impressive book. Having said that, I still have some questions. My question is directed to, in a way, the scope that can be given in terms of protecting a fictional character. Because I have the feeling that you are, or the approach is very much pro-copyright owner to the disadvantage of the rest of the world that should be free to make similar kind of works. If I look at your first proposition, you say fictional characters can consist of narrative functions consisting of interpersonalities and relationships, and depending on the media used in the source works, their formulation may include other elements, chiefly images. I'm not claiming at all that I would have a better definition than what you put in writing here, but nevertheless I struggle a bit because under case law of the European Court of Justice in Levola, about the taste of an ingredient, how that can work, the court stressed that a work should be identifiable with sufficient precision. And that sufficient precision seems to indicate that, well, first, that the flavor concerned probably didn't meet that test, and that it needs to be very exact in a way what is protected, also with a view to what the scope of protection thereof might be. And that brings me to my dilemma, which is what do we do with Superman's nephew? Being Superman's nephew, there will be clear resemblances in the way they look physically, their characters, their family members. But nevertheless, I would think it should be possible to come up with a story about Superman's nephew without infringing any copyrights in Superman itself. And there my problem is a bit, how do we draw that line? And I wonder whether you can elaborate on that. And my conclusion, but that's also a question, is that at the end of the day, if we give protection to fictional characters, which I fully understand, but the end result is probably that you are protected against very clear copies, but at the end, that the protection as such should be narrow. So Superman's nephew is free for the taking by other creative powers. What's your position on that?
Thank you, highly esteemed opponent, for the question about the scope of protection. As a preliminary thought, I think my research is descriptive. That this is what I present what courts do to protect fictional characters. And regarding the policy of the European Union, I think sufficient precision has a different, well, it should be contextualized in the EU copyright policy, that culturally how sensitive we are in to a kind of work, and how the viewers respond to a particular character determines how far we are willing to protect it. Because I think this is also, and this is especially a generational thing, that younger generation no longer react to Superman with the same enthusiasm as their parents. Sorry, no offense, but the problem is that if a character is fictional, we have to also make sure that it is not imaginary. What is imaginary between the Superman that people see and read and the Superman's nephew is, technically speaking, imaginary. Therefore, in certain jurisdictions, you can say for sure that this is not a copyright infringement, but that use may also trigger the issues about unfair competition. However, if you go to the United States, then protecting a fictional character as a separate work would most certainly lead to any use referring or depicting, alluding to that character would amount to a form of copyright infringement. In Germany, although as a case in Europe, in Germany, protecting a character as a separate work means, in some degree, that using this character is somehow exempted, that this character, as the common knowledge of a generation, is almost anticipated to serve as a cultural good, like a common good, that it needs to offer its cultural share to the mass. In China, I think it's hard because most people don't really react that much to Superman other than the movie. I think in terms of comics and therefore especially since the comics of Superman is not that big in China, then using a comic image of Superman bearing similarity to the nephew does not. If depicting the nephew's image with similarity to the Superman does not really amount to a form of copyright infringement. That's my preliminary thought on this issue. So to conclude, the precision thing is the precision, the requirement of definition, the requirement that the work should have a scope that's sufficiently precise depends on the audience. I think in mainland China, the reaction is weak. The cultural resonance to a certain cultural phenomenon is the weakest, and therefore the protection is likely the weakest. In Germany, a bit stronger, but chances are that it's not as strong as the United States. That's if that satisfies the opponent.
In that case, the opposition will be continued by Professor Kong-Chiu Niu, who is Professor of Law at Singapore Management University. That's a university that we have very close ties with here in Maastricht. And also for that reason, it gives me great pleasure to have you here. Very much welcome to our university. You are also a member of the assessment committee, and I'm very happy to give you the floor. Please.
So, dear candidate, well, it's been a long journey. Like Germans said, du bist ja jetzt so weit. So it's a long journey, and I'm very privileged to be part of your journey. So I noticed that you have made substantial revisions of your first draft, and also made substantial additions, which address many of my my first round questions already. So I'm happy to see that, and thank you for that. But nevertheless, as opponent, I'm supposed to raise still some questions. So I will have two questions, but I will start with the first one. Actually, my question is really to get you a bit relaxed, and it's just to warm you up for the rest of the defense. I'm sure by now you are by far the true expert in this topic within the copyright law realm. But then in the future, I'm sure you're going to be a teacher teaching general IP as well. So I would encourage you to actually take a broader view of IP, not just limited yourself in copyright. And therefore, my questions for you is then just reflect a bit on. Can you draw some parallels or analogies between the topic that you are doing, which is limited in copyright, with other area of IP laws? Such as patent law or trademark law. Do you see any parallels? Do you see any analogies? Do you see some commonalities so that your study can be inspirational for other area of law, or vice versa? Or how can you see some, so to speak, cross-fertilizations between your work, specific work on copyright, and other similar works in other area of IP law? This is actually a very broad topic, and you're free to answer. Thank you.
Thank you, highly esteemed opponent, for your kind words and intriguing question. It's very thought-provoking. Taking an adventure out of my comfort zone, I think the topic of fictional characters has more relationship to do with trademark than patent. But I can see that there is a general parallelism between these, among these three, between them. Regarding trademark, it's interesting, especially in the case of the US, that judges in general requires that a character be distinct outside the content, outside the context of the source work in order to protect it as a separate work. And the distinctiveness requirement is a typical requirement to register a trademark. Does that mean that a character, at least in the US, that can be protected separately has to do with, have to de facto be the trademark of a story to be protected as one? Because in some way, it makes sense to connect copyright with trademark in this regard. Originality in terms of copyright is and should be a low threshold to encourage creating works and protecting works. However, in the case of protecting fictional characters, then judges also set a high bar to be distinct, which is not usual for the admission of work. I think this incongruency, this gap between a low bar and a high bar to protect a character is an effort for judges in the US to harmonize copyright with, to have a common frame of reference to protect copyright and trademark. Therefore, it is possible that the US tacitly operates a system to protect unregistered trademark for indefinite categories of product and services and indefinite time based on or excessively long period of time based on copyright. And regarding copyright and patent, on my topic, I see that the idea expression economy is central, but I also see that in patent there is a SCP system that is certain patents are so essential for technological development in a particular field that they have to be licensed, but in this way their protection is restricted, but right holders gets fair compensation in return. I cannot really say much whether an idea is so central so that it has to be idea, but in terms of technological development, then it is testable whether a technology is essential or not. So perhaps the abstract nature of idea is as stepped as the testament of technological innovation, but I cannot really. I can only see that there is parallel in the very abstract nature. And I can only see the parallelism in the very abstract nature. And copyright still remains largely an island. Thank you very much.
Okay, just think about dependent patents, okay?
Thank you so much. The opposition will now be continued by Professor Zemsleben, who is Professor of Intellectual Property Law at the Universiteit van Amsterdam, and who is also a member of the Assessment Committee. And I would like to welcome you very much to Maastricht University today. Wonderful to have you. You have the floor.
Thank you so much. Dear candidate, it was a pleasure reading your work. I'm particularly impressed by not just the cross-national comparative analysis, but also the theoretical metrics that you add to all your analysis. Having said that, I wouldn't be sitting here if there weren't a couple of questions that I can still imagine and that I think are not completely answered in the current version of the book right now. I'm particularly interested in your discussion of the free use and pastiche developments in the European Union, and then in particular in Germany. And What gave me a bit of difficulty and a pause is how you draw a line between the former broad free use provision in Germany, the former Section 24 of the German Copyright Act, and the current Japanese approach to text and data mining, which is an exemption of uses for non-enjoyment purposes. And so here's the reason why I'm hesitating here a bit. I get your point that you say both are, from a legal doctrinal perspective, carve-outs, internal restrictions on rights, as you say. I buy that argument, but then you could also add the exhaustion rule, which is also an internal restriction on rights. So that doesn't convince me. Don't hide behind this legal doctrinal thing. I'm more interested in the rationale, the objective. So why bringing this up at all? And there, with regard to the Japanese non-enjoyment rule, you say, well, the purpose is the promotion of the production of technology, services, and products other than works. And this doesn't make much sense to me in the case of an analysis based on fictional characters. So here is my question, hoping to stimulate your thinking a bit. So can't we say the free use provision that we had in Germany, this is a positive thing because it supports derivative works, follow-on innovation in the human creative space, whereas the broad non-enjoyment TDM exception in Japan kills human creativity because it enables new technologies that finally put an end to human creativity, so you can't compare those two. Or am I overlooking something that justifies the line between the two?
Thank you, highly esteemed opponent, for a very interesting question. I think there is a distinction that has to be made. The distinction you pointed out is no doubt valid. The reason why I raised the Japanese non-enjoyment exception is that I want to distinguish that what copyright protects. If we talk about a work, then we think about an intangible subject matter. Works are intangible, but it cannot be consumed unless it has a tangible means so we can consume. So the relationship, so when we protect a work, and then it's like when we talk about a body that has a mind or a ghost, and then you have also that has a mind and it has a body. So the mind work is like the ghost, and then the body is like the shell. This is the relationship between the intangible work and the copy undertaking the work. So when we talk about copyright protection, we have to understand what is being protected and what the protection of what is being restricted. When the uses of fictional characters is a case, when content, the intangible part, is used. However, the protection is also limited to prevail, to make copies, if not access, available. The Japanese non-infringement exception is a case that makes copying possible, but it's used for the convenience of the copy, but it's not necessarily used for the for the inspiration of the content. Whereas I think the German free use and parody character and pastiche are directed at the enabling of creating new content. I think these are indeed two parallel streams of protection. However, if we put ourselves in a bigger picture in the US, if we take a broader view of copyright exceptions, sometimes we say that works can be used in under certain conditions, and sometimes we say that copies can be made on certain terms. I think there is a distinction, or there is a tendency that we cover, let's say, we use permitting copying to replace permitting the use of works. And that this is a concerning tendency that tightens up copyright protection. As is often said, copyright is the child of technology. There is an element of truth, but we should not subsume, we should not think about technology, we should not primarily think about technology when we talk about copyright, because technology is responsible for copying, that's true, and the marriage between copying and the creation is always with tension. The creation part hasn't changed much throughout the century. However, the means to copy has advanced drastically over the past few decades. I hope that satisfies your question.
Now the opposition will be continued by Professor Moerland. Professor Moerland is Professor of Intellectual Property, Frontier Technologies and International Trade at our university, and is also a member of the Assessment Committee.
Thank you, Prorector. Dear candidate, I would like to compliment you with a very well-written dissertation that presents a fascinating theoretical, doctrinal, and practical case study into the phenomenon of fictional characters. I think it's well-structured, clear in style, and particularly appealing due to the thoughtful examples from literature that enrich the topic of the thesis. Your thesis is at the interface of copyright protection and freedom of expression. And that makes your comparative approach that involves China, Germany, and the US highly interesting. This triggered my interest in how you take cultural differences between those countries into consideration in the comparative part of your research. Your methodology section still does not provide a clear explanation of this, which allows me to push you a bit further on that aspect, particularly as you note yourself in your proposition 9, and you mentioned it today as well, copyright protection is not aesthetically neutral. And I may add, it is also not cultural neutral. In fact, the way countries regulate copyright strongly reflects cultural choices. The justification in which copyright protection is built upon the legal tradition of a country and societal preferences differ from one country to another. However, they strongly determine how legislators and judges approach, for example, the originality of works and derivative works, being a form of cultural participation and freedom of expression. Hence, my question is, how did you take the different legal traditions and cultural preferences of your case study countries, being the US, Germany, and China, into consideration in your comparative part of your thesis? And in other words, how did these differences play a role when determining the legal assessment of the idea-expression dichotomy or relevant exception or non-infringement tests in these countries, with the final goal of drawing conclusions for China? Thank you.
Thank you, highly esteemed opponent, for your encouragement all the years and the very challenging question. I think the legal tradition part and the cultural differences does, as you mentioned, affect copyright protection. In the case of mainland China, we can see that in the case of mainland China, we can see that judges tend to refrain from judging the artistic merits of a certain work, preferring to analyze on the formal part. For example, if the artist didn't present a character separately, it must mean that the author did not intend it to be a separate work, etc. So I think this is a judicial refrain that judges do not want to to air their view outside the legal realm. I think there could be a cultural aspect in this regard, because judges in mainland China are quite technical in their deliberation. They generally copy the facts from the submission of the plaintiffs and respondent when they deem that a fact is valid. Therefore, they do not do the storytellings by themselves. So this is a bureaucratic attitude towards narratology. A contrast would be in the US, that judges are quite active in narrating the facts so that they can build their legal arguments more persuasively. So I think the cultural difference in combination with legal tradition affects the judges' willingness to go out of the legal technicalities to be fair in their understanding. Another perhaps difficulty is another influence from the cultural aspect may come from the Chinese language itself. As we know, that Chinese is hieroglyphical, so characters developed from drawings, and there are certain drawings that preserved in certain patterns, preserved and still persists as the part of speech in the Chinese writing. Therefore, Chinese judges are probably unwilling to say, okay, here we have a distinction. There is a distinction between languages are abstract. It is true, abstract, but we shouldn't say that a written work should be protected to a thinner degree than the graphic works, because there is still this cultural connection that our writing comes from drawing. Same applies to Latin alphabets, but the connection has been let's say, the connection is nearly in existence by contemporary memory. That's my understanding. So, in the application of the idea-expression dichotomy, for mainland China, if you say that the German approach is to go through I think regarding their role in the idea-expression dichotomy, I think the American approach is quite contrasting to the Chinese one, due to judicial activeness and the bureaucrats in mainland China to refrain from taking risk. And in Germany, it's the legal construct is more rational, you can say. You can say that there is more institutionalized practices as to how to speak how to speak protection and how to deny protection. But the problem is that mainland Chinese judges are more convinced of American practices, even though the legislation has more connection with Germany. Therefore, what they try to do is to speak American rule through a text that has kinship with the former German Copyright Act, which leads to the result of twisting various rules. Instead, they can just turn to Germany and find inspiration there to see that their established practice, at least before the European harmonization kicked in, to provide, let's say, flexibility or to level up the strength of protection. That's my thought on the cultural difference and legal tradition.
Now the opposition will be continued by Professor Philipsen. Professor Philipsen is Professor of Law and Economics at our university and is also Professor of Shifts in Governance at Erasmus University, Rotterdam. Please.
Thank you. Dear candidate, dear Ms. Lin, I would like to follow up on the compliments made by my colleagues before me and compliment you on finishing this wonderful book here. The book not only includes legal analysis, you also make actually quite many attempts to include economic analysis in the book. And since my expertise happens to be in the domain of law and economics, it will probably not surprise you that my question will also relate to the economic concept used in your thesis. I had several options. I was considering to ask a question about the price discrimination in the sale of access, or your story on positive and negative externalities of unauthorized use. But in the end, I decided to go for something else, because it's one of your recommendations. And you left me, well, actually curious for more. In the concluding chapter 8, you present a number of recommendations, and you probably know which one I'm going to highlight here. One relates to the economic concepts of public goods, common goods, and club goods, which are all somewhat related concepts in that they all deviate from the standard private goods, but of course they're also clearly different concepts. More specifically, club goods, like a pure public good, are non-rivalrous in consumption, meaning that several or even many people can use it at the same time. Common goods are rivalrous in consumption, but it's difficult for producers to exclude people from using them, which generally leads to the problem of overuse of a common property, like what we see in overfishing and the example you provide of overgrazing on a field of land, probably even maybe inspired by the law and economics course long ago in which we discussed that very same example. Now it comes. You write on page 264 that the economic analysis of copyright should treat works as club goods rather than as private goods or as semi-common goods. This may be correct because when access to works is limited as a result of copyright law, only those who pay can legally consume the work, so I can follow that reasoning. However, payment is in principle possible for anyone. The non-rivalrous character of copyrighted work, also essential to qualify a good as a club good, has indeed also been acknowledged in the literature, but there appear to be differences in opinion between scholars, whether it really applies here to this context. So while preparing this question, I already did some quick online research in that literature and found that your qualification as a club good may hold particularly in digital context. Physical copies like books or DVDs are clearly rivalrous, but their digital versions are not. So you write yourself on page 265 that some literature misleadingly qualified works as common goods, because works cannot be literally overgrazed like land, but people can lose interest in a work. Okay, this leads me to the question you're wondering, where does this all go? It actually consists of two parts, one very brief clarification part. So the clarification question is, do you mean to make a general claim for all copyrighted works, or all works to be treated as club goods, or do you make this claim only for particular works? So that's just to set the scene. And then the real question is, if your suggestion is right, and I'm inclined to accept, so what would be the implications then of classifying works protected by copyrights as club goods? So what does economic theory then suggest we need to do, for example, in terms of regulatory intervention, or what courts should do when dealing with club goods? So what does this recommendation really mean? I very much look forward to your answer.
Thank you, highly esteemed opponent, for your kind words and very and interdisciplinary question. And as a clarification, I mean that I think works in general should be treated as club goods instead of private goods. However, we shouldn't say for sure, because the works as a general term still have to be considered what kind of work it is. Each jurisdiction may define work using its own term. For an example, in the case of the US, then visual arts are limited to 20 copies. Therefore, a copy must exist for visual works. In contrast, if we consider works of fine art, especially digital art, once you draw an image on your iPad, tablets, and click Save, and then you have a work of fine art, but where is the copy, or where is the original copy? In this sense, there is no original copy. If you close the app and reopen it again, it could be another copy, or if you copy it to other devices, that's another copy. So we can say that in general that works should be treated as club good. That's a more universal possibility, that works being private goods with excludability and rivalry are the cases more restricted to depending on the tangibility of the access or the copy. That ties back to Professor Zentleben's question, which I alluded to, the marriage between intangible subject matter and tangible means for consumption. And as for the second question, implications about court, I think recognizing works as a club good brings out a better or broader understanding of the economic significance of copyright, that works are nowadays often securitized, that the receivable are often pooled together with other assets and listed together funds. And this is not the traditional understanding of economic, this is not the traditional understanding of economics we associate with works. If we model it after private consumption, like buying a book, selling a book, but the financialization of a work or a group of works may go into a different bubble parallel to the actual consumption of a work. So I think recognizing works as club goods opens up a new realm of of law and economics to process works not only as a a subject of consumption, but also a subject of investment. May that please your interest.
Yes, I'll accept. Yes. Thank you.
Thank you so much. In that case, I'm very happy to be able to allow a second question to Professor Kongqing Liu. Please. I think you should still unmute your microphone, Professor.
Oh, yes.
Yes.
Like all theses, you have the main concrete suggestions at the end of your thesis. If we take out the club goods parts, perhaps according to my reading, this concerns pretty much all about courts, what courts should do in Mainland China. But then in that regard, you only suggest that the People's Supreme Court should actually come up with some some rules or guidance on the dichotomy between idea and expressions of idea. We all know that in Mainland China, SPC play a semi-legislative role, okay? And in order to make suggestions to them, in order to make your suggestion actually more feasible on the Chinese ground, actually, perhaps you should address very specifically which piece of rules or interpretations or regulation that SAP has issued, so that it can then accommodate your suggestion. So I think perhaps 最高人民法院关于著作权民事案件纠纷适用若干法律问题的解释 that has been in existence for over 23 years, and perhaps you can then focus your suggestions onto any of those existing SBC semi-legislations that will actually make your recommendations a lot more feasible in Mainland China. So what do you think?
Highly esteemed opponent, thank you for your question. Could you please elaborate a bit more so that I can understand your question more to the point?
Yes, actually, the way I look at your suggestion at the end of your thesis, it is all targeted at courts. Courts should actually better understand all the issue that you are addressing. But in order to lead courts to that right direction that you are pointing, you suggest only that the SBC should address the issues of dichotomy between idea and expressions of idea, but then otherwise, well, it's just left to judges or courts in China. But then perhaps in order to make your suggestion more feasible, and also taking into consideration that, well, SPC in China plays a semi-legislative role, perhaps your suggestion can be then further concretized in which specific interpretations or regulation issued by the SPC should be revised in what way, to what extent, so that not only SPC will better grasp the point that you are mentioning, but other courts, lower courts, can also follow your suggestions. Thank you.
Thank you, highly esteemed opponent. As in honesty, I don't think my answer is going to be pleasant to you, because I think invisibility is also an advantage in this regard. As copyright further develops, there is a certain trend that we must protect copyright at higher and higher levels. Especially when China negotiates a free trade agreement with other jurisdictions or economies, then its IP policy is often required to level up. And in view of this development, it's necessary to preserve flexibility, even at the cost of transparency.
Xi Lin, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company, both here and online, await the results of our deliberations and our return here in this room. Xi Lin, the degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Kamperman-Sanders is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Do you promise to work in accordance with the principles of scientific integrity at all times? To be careful and honest, transparent, independent, and responsible?
Yes, I promise.
By authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Xi Lin, the degree of doctor and grant you all rights attached by customs and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university.
Dear Dr. Lin Xi, I would like to congratulate you in the completion of an intellectually enriching 5-year-long evolutionary journey, resulting in a thesis that you presented so eloquently and nicely today. For me, it has been a great pleasure to be your co-supervisor alongside colleague Professor Kamperman-Sanders, and I feel very glad and happy to say a few words on this occasion. Looking back in time, we first made an online contact in November 2020. This indeed was a moment very difficult to develop any contacts, particularly in light of the lockdown situation. Lockdown, as we were in very different parts of the world, we continued to interact and your research continued to evolve. The restrictions on physical mobility in no way limited your infectious enthusiasm or interest in copyright. It was not until 2 years later, in 2022, that we first had the pleasure to meet in person. We knew each other intellectually, as we had met online, as I had read through and commented on your work on parts of your thesis. But what I did not know was you as a person at a personal level. And this was the moment. And with each follow-on meeting that we have had since then, whether in person, whether online, or via long email exchanges, ranging from our meeting at PhD workshops and conferences, wherein you made a very impactful presentation on AI-generated works and litigation in China, to our meetings in office, or a simply relaxed setting in the favorite cafe down the road, your intellectual curiosity took a wide range of twists, turns, and adaptation on the issue of fictional characters. Over time, it became evident to myself and Professor Kamperman-Sanders that your thinking transcends the strict confines of legal, dogmatic world of law. I fondly recall, and this also came up in the questions today, a discussion on your creative economic model on the monopolistic market tendencies in fictional characters. and how the strategic intolerance or tolerance of copyright infringement in China makes a positive economic impact. You also brought in your discussion the rich Chinese cultural heritage to highlight how copyright does not work in a vacuum. Instead, it is very deeply interwoven in the fabric of the culture, the history, and the heritage of a nation state. Impressive as it was, you did not just limit your research to China, but you also navigated through the framework in the United States, the European Union, with a special focus on Germany. For historical reasons and the influences of these jurisdictions, it offered a good approach to look at the core consideration of your thesis, which is, how does the Chinese copyright law protect fictional characters according to copyright norms and the right holders' deployment? Professor Kamperman-Sanders and myself, we always knew it, that you were very ahead in terms of your thinking. But we also found an element of abstraction in your thoughts. So we challenged you, and we continuously challenged you to translate your thinking into an accessible format for a larger audience. We asked you questions, and in return, we continued to receive very long responses, clarifications, and revised versions of the work from you. There was a catch, a challenge. And the challenge, however, was that each revised version was very different from the earlier version of the work. Although they also ran a common thread throughout. And that thread was the fundamental research question, and most pressingly, your perseverance and commitment to your thesis. Additional elements, revised new versions, reflected only the diversity and the richness of your thoughts, your work and your determination. So overall, my sincere, heartfelt congratulations for the result of this years of hard work, dedication, and commitment for this thesis and your very successful defense today. We all believe that with this wonderful contribution to the world of copyright, you have proven your agility and are very well established to make not a fictional, but a very real impact in the world of copyright and intellectual property rights. Congratulations, keep going, and please, we are very excited to be a part of your celebration party afterwards. Thank you.
Dear Dr. Lin, also on behalf of our university and its Faculty of Law, many congratulations on the degree that you have just acquired. I always say it's the highest degree we have available, and that's really true as a university. Congratulations to you, congratulations to your family and friends, both present here in this aula, but also participating online. Do celebrate, starting with the reception, and perhaps still something after the reception as well. To celebrate, I would say with or without Superman and his nephew. We will see about that. I have one practical remark to everyone who is present here in the aula, which is that the reception will take place at the in the Refter. And I would like to ask you all to already go there while we still stay behind for a few more minutes with our young doctor and her paranims, who also did a great job today, I should add, and with your committee and with the BIDO and of course your supervisors to take the traditional photo. And we also like to have, of course, Professor Liu on that photo. That's why we will take the photo here. I have already identified 3 photographers in the first row, so they are absolutely allowed to still stay here to make that photo. Congratulations again, and with that I also officially close this academic ceremony.